Listen up, get ready, I'm not gonna take no more. There's a revolution, a revelation going on in my soul. Buckle up, get ready, we're not gonna sit down.
Welcome back to Live from the Heartland for the week of July 17th. I'm still Michael James, and I'm here with my friend from the 49th Ward, Ed Mullen. He is a lawyer, a public policy advocate here in Chicago. His legal practice focuses on representing victims of discrimination, sexual harassment. He represents clients in employment disputes, represents candidates and elected officials in election law and related matters. He is an all-around good guy, and he just coming off a victory around the Chicago School Board candidates. Why don't you start with that, Ed? Give us a side of good morning. Tell us what that victory was all about.
Absolutely. Thank you for having me on again. It's always nice to talk to you. The Chicago School Board, for the first time this year, will be an all-elected school board. 2 years ago, half of the school board was elected for the first time, and this year we'll have the first fully elected school board in the city of Chicago. We had 21 open seats. Almost all of the candidates that were in competitive races had at least one challenge, and there was a single challenge that was running through at least 20 of the different candidates that had filed their nomination papers, and that was what we call the dual circulation objection. And essentially what the objector was arguing was that if a person had circulated a petition for a Democratic candidate to be on the ballot for the March 17th primary, they couldn't then circulate a petition for a nonpartisan candidate on the November ballot. And that stems from a rule that says you can't circulate for Democratic or Republican Party candidates in the primary and then circulate for independent candidates in the fall. And that makes sense because independent candidates run against Democrats and Republicans. And there are lots of public policy reasons why you wouldn't want people to, voter confusion, games that people can play, etc. But those public policy considerations and the language of the statute don't actually apply to nonpartisan candidates. But there is a provision in the law that says where not otherwise consistent, rules that apply to independent candidates should also apply to nonpartisan candidates. And so they tried to take these two provisions of law and put them together and say that if you circulated for a Democratic candidate in March for the primary, you couldn't circulate for a candidate that's nonpartisan. But the First District Court of Appeal in Illinois has said specifically that this rule does not apply to nonpartisan candidates. The reason I think they brought this objection was because that case was relating to a consolidated election for a municipality. It was not a case where you had a primary and a general election. So they were saying it only applied to the consolidated election. And the board heard argument on that objection for all of the 20 some odd cases that it was made in, and made a joint ruling that that objection would be stricken from all of the objectors' petitions and would be deemed to be an invalid objection, which I think is legally and from a public policy standpoint, the absolutely correct ruling.
Well, I'm glad you won that one. Let me ask you, do you have a sense, were the challenges across the board, all 21, were they from, let's just say, elements not as progressive as the candidates?
Absolutely. In this case, most of the candidates who received objections were more progressive, either supported by the CTU, appointed by the mayor last cycle, or otherwise more on the progressive side of the spectrum than the ones that were not objected to at all. Absolutely. And, we know that the money is coming from, folks that are opposed to CTU and the mayor having influence over the school board elections.
For people who don't know about the CTU, that's Chicago Teachers Union, And they are quite a powerful outfit in this town. And most of the time we like them. And Ed, one of the things that's going on in the country is a lot of what I would say is malfeasance around our elections and attempts to suppress the vote. They're coming from on high. I'm sure that happens from the lowest level all the way on up. You and I both know that ICE has been more active again recently, not only in Chicago. There have been, as we said at the outset of the show, 2 murders or assassinations of people by ICE in the last week. What happened up in Michigan in ICE's attempt to come on the scene during an election?
Right. Well, let me preface this by talking a little bit about what happened in Illinois in our primary election, because there were a lot of organizations, immigration rights organizations, the Chicago Civil Rights Committee, Lawyers Committee for Civil Rights, I forget the exact name, and a lot of the candidates, as well as the Attorney General's office, did a lot of work to prepare for what might have happened in Illinois in the primary, because we thought it might be used as a training ground for what they might try in November. And really nothing happened on election day. There was some sightings of ICE out in Schaumburg, in a place where they were not usually seen, but it didn't seem really coordinated, and it didn't seem related to the election. So, I think folks were a little bit pleased and mildly surprised that there was nothing that occurred on election day in Illinois. But we had we've had situations up in Michigan where we haven't had election day yet, but that ICE has gone into the polling places and tried to enforce immigration laws inside the polling place. And there's concern that that's going to escalate as election day approaches. And the difference between Illinois and Michigan, of course, is that Michigan is much more of a swing state than Illinois is. So it makes sense that they would try this out in Michigan. And so I think it's going to be very interesting to see what happens on primary day in Michigan in early August, and I think we should be watching that very carefully.
How does this relate to the feds going into Atlanta and wanting to look at the polling place and get the numbers, et cetera? That's been in the news.
Yeah, it's been in the news. It's sort of a different type of issue, though. You've got ICE, which is trying to suppress the vote and make it so that it's more difficult to actually get to the polling place and cast your vote, and that people might not show up at the polling place because they're fearful of it. So that's on the voting end. But the Department of Justice and some nonprofit organizations on the right side are trying to make it so that it's more difficult to count the votes once the votes are cast. And so there is some concern of the government seizing voting machines on election day before the votes are actually counted, to try to make sure that votes that are leaning Democrat are not counted. We see out in California, Governor Newsom has taken steps to pass a law making it illegal for anyone other than state election officials to seize or to have control over the election machines. Of course, the courts are going to have to decide whether, federal authority versus state authority controls in that type of a situation. But I think it's going to be very interesting to hear what the president has to say in his live address Thursday this week. And I don't know when this is actually airing.
We don't come up until Friday morning, so we're going to miss that. Yeah. But I assume that he's going to talk about voter fraud and, just try to scare us to death.
Yeah. And there was a very interesting interesting quote. It says, if we allow elected officials to violate the law in cases of emergency, they will create emergencies so that they can break the law. And it seems like that what is the theory here. And they're attacking this at all sides, right? They're not just going after one piece of the process. They're going after, intimidating people going to the polling places, intimidating people who are trying to count the votes in a fair manner. And what they're also trying to do is make it more difficult for people to use the vote by mail system. And we had a Supreme Court case that came down last week where the administration and the Republican National Committee had sought to invalidate a Mississippi law that allowed for the counting of vote by mail ballots after Election Day as long as they were postmarked by Election Day. And that's how a lot of states around the country, including Illinois, count their votes. And so the Supreme Court said it was okay as long as the ballots were postmarked by Election Day for the state to allow them to be counted when they were received after Election Day. And that was a surprising victory in some extent. It shouldn't be surprising. It should have been an open and shut case. But the fact that we had 3 or 4 Supreme Court justices that thought that federal law could preempt state law on voting, number one, and number two, that we could invalidate votes that were cast on Election Day that were valid under state law based on federal law. And so that was a good decision. But that isn't the only thing that the administration is doing with respect to vote by mail. They've been trying to create a national voter registration list. And it seems what they want to do is call people who they believe are not eligible to vote, but you would assume that those are folks with ethnic names, whether they be Hispanic, Latino names, or Asian, Southeast Asian names, and call those people from the voter rolls. And it would be done in this case so close to the election that people wouldn't really have an opportunity to cure those issues. And what they're trying to do with respect to their control over the post office is to make it so that the post office isn't going to deliver vote by mail ballots unless those people are on the voter rolls. So while the federal government doesn't have any control over what votes the state counts, what it can do is refuse to allow what it can try to do, I should say, is to refuse to allow the post office to deliver ballots that are certified by people who are not on the national voter registration list. And then the election authorities would never, ever get those votes, and they won't be counted because they wouldn't have been received. And so that's how they're trying to get around their lack of control over the local election authorities. But there have been, I think it's 12 now, cases where federal courts have said that states are not required to give their voter lists to the federal government. And that's been, I believe 12 federal district courts now have said that the federal government is not entitled to that information. But at the same time, there are states that have voluntarily given it and not fought the issue. So the federal government does have that information in some states. Thankfully, those states are not the states where we would expect to have close elections in the fall. They tend to be the more red-leaning states, and so states like Michigan and Wisconsin and other states where we're going to be in a fight for the presidency and the House and the Senate, they've held firm and not provided that information to the government or the federal government, I should say. And it's hard to see how this late in the cycle anything like that could be implemented.
Ed, why don't you just briefly on the courts from the Supreme Court on down? I mean, every once in a while we get a ruling like the one you just mentioned from the Supreme Court that says, oh, well, okay, that's good. But basically it has gone the other way. But there have been a lot of courts around the country who have kind of stood with the people, let's say, as opposed to the administration's attempt to suppress the vote. Are you optimistic about the judiciary being able to continue to block some stuff, or do you have some threats looming that you're aware of?
Right. So I think that's a really complicated question, but what I think has been most telling is that people who have challenged actions of the Trump administration, particularly related to rights, have done very well at the district courts and, to a large extent at the federal appellate courts. And the reason for that is because those courts follow existing law, right? There's Supreme Court precedent, there's appellate court precedent, and the district courts follow that precedent. And even a lot of Trump appointees and Republican appointees have been, applying the law to say that the Trump administration is overreaching and, potentially violating federal law and what they're trying to do with mail-in ballots and some of the other voting-related issues. But once it gets up to the Supreme Court is not as bound by precedent, even though they stare decisis is supposed to be a very well-ingrained theory in law that you follow existing precedent, you don't reverse it, you can modify it, you do it incrementally. This current Supreme Court seems to have ignored that theory in a lot of cases and is taking very significant jumps in changing the law relating to voting rights. And I think the recent case on the Voting Rights Act, that we could spend a whole 20 minutes talking about, is emblematic of what they have done, not just on the substance, but also on the procedure and the implementation. What I mean by that is when the courts found several years ago that the Alabama map violated the Voting Rights Act, they said it violates the Voting Rights Act, but we're not going to change the way this election that's upcoming is going to be run because it's too close to the election. It's called the Purcell principle. And in this case, when they found that the Louisiana map was constitutional under the Voting Rights Act, they stopped the election in the middle. That people had already been voting in the election, and they stopped it to redistrict so that they would take away the majority black or a majority black district in the state of Louisiana. So on the substance, they were hostile to the Voting Rights Act. And then in the implementation of their decision, they were, I believe, hypocritical in allowing the decision to go forward in this election in the fall, when they hadn't done the same just 2 years ago, when the Democrats had won this similar issue in Alabama. So I am not very optimistic about how this Supreme Court is going to resolve any issues that might come up in the November election. I would be very concerned about any issues that come before them in November.
I was going to ask you about Save America Act, but we'll save that. We only have a couple minutes left, Ed. So what do you think people should be doing to protect the vote, to protect our upcoming elections, since an awful lot of our futures will depend on what happens?
Yeah, so speaking specifically to people in Illinois, we have an organization in Illinois called Operation Swing State, where people who live in Chicago and know the outcome of the November election in Chicago and can early vote in Chicago, they go to Michigan, they go to Wisconsin, and there are multiple organizations doing this. I don't want to necessarily, limit it to Operation Swing State. It's just a good example of it. But I think this is a really important election because, everyone says it's the most important election of your lifetime. But I do think that the outcome of this election really is going to determine whether we have a functioning democracy in the country come 2028. And I know that might seem hyperbolic, but I do truly believe that.
Ed, I want to thank you for coming on, and I'm going to invite you right now to come on again pretty soon, talk more about election malfeasance, because one of the things we grew up appreciating in this country is we had a right to vote and determine the way things were going to go. And that's been challenged pretty significantly. And our future rests really in our own hands, what we can do to prevent this BS and secure our future. Thanks so much for coming on the show. And we'll see you in the neighborhood real soon.
Thank you.
Adios. And everybody else.